Calling on the record. We're on.
Okay. We're here on case number D500910, Jensen versus Jensen. Counsel, please state your names and bar numbers for the record.
Thank you, Your Honor. Patricia Vaccarino, bar number 5157. I'm present, and I believe Caroline Jensen is present by phone.
Okay.
Sabrina Dolson, appearing on behalf of defendant Shane Jensen, bar number 13105. Shane Jensen is also present, as well as Joseph Caraccioni.
And Mr. Caraccioni, what's your bar number?
10634, thank you.
All right. First, I have two questions that are kind of sort of housekeeping, if you will. Did you get any sense from the Supreme Court as to where they might be leaning when you had your oral argument?
Yes, I did. In fact, I feel like all along they've been kind of leaning in the direction of granting the writ because, for one thing, when they filed the motion for fraud with your court, they filed the simultaneous one with the Supreme Court, and you usually get a limited amount of time, 7 days, to oppose a motion in the Supreme Court, but they just granted it within 2 days. So before they scheduled the oral argument, I requested by emergency motion that they at least see our response, because alleging fraud could persuade a jurist. We just asked that they receive it. So they responded, the other side, the petitioner, Shane Jensen, and said they didn't oppose the Supreme Court reviewing our opposition that you have in front of you, only if they would read the reply, but they denied the relief, went forward with oral argument, and the question that was asked is, I don't know if you're going to get a reverse and a remand, is you stated under the rule that during a consultation, Bob could have, instead of did receive, confidential information that could be substantially. So you used the word could have instead, indeed did. And I believe that's that point alone, in my objective opinion, was a question asked. Certainly, though, also the quest to get
was. I got your take. Now, I want to hear from either Mr. Caraccioni or Ms. Dolson, whoever did the oral argument on behalf of your firm.
I did the oral argument, Your Honor, and we also agree, based on the questions that were asked, that the Supreme Court did seem to focus on whether or not actual privileged confidential information was provided to Mr. Dickerson. So based on the questions that they seem to focus on, we do think that the writ will be granted.
I think it may be granted with a request for further.
Counsel, Ms. Vaccarino, let me make something perfectly clear. I've had to make this clear in person hearings, but it's even more crucial in video hearings. With in-person hearings, if I'm talking, nobody else should talk, nor should anybody talk over anybody else. But in video hearings, in blue jeans, if one party talks over the other, nothing gets picked up on jabs. So let me finish my inquiry, okay, and my statements. So, as Ms. Vaccarino looks at it, it looks like the Supreme Court to her, we're going to deny the writ. According to Ms. Dolson, her perception of the questions was that the Supreme Court was going to grant the writ, right? Is that a fair statement?
No, they both said that they were going to grant, that they both had the impression that the writ was going to be granted, I think. Even Ms. Vaccarino said that.
I said that they... Okay.
She said the contrary. So we don't know what they're going to do. And you know what? I participated as an attorney in enough arguments before the Supreme Court that I know that a lot of times the questions they ask are just that. The questions they ask, because then, was it en banc?
No, Your Honor.
Okay.
Your Honor,
so
I would like to clarify that I don't know if you're clear on my...
Haven't called on you. So it was a 3-judge panel, correct?
Yes, Your Honor.
Okay. So we don't know, and then we don't know whether or not it'll end up before a full panel. Because you know that if the three-judge panel grants a writ, it's still up to the party who is unhappy to ask that the full panel address the issue. We all know that, okay? So chances are this is an issue that that may succeed me in time, I don't know. But in any event, I have my second question. The plaintiff move outside of the state of Nevada? Yes or
Yes.
no?
Yes, she did.
Yes.
Where is the child?
He's with his father for the summer, as the current judgment actually allows him for alternate visitation outside of the state, and mom gets residential time. Your case is 100% state, obviously, pending the Supreme Court, and I do think that you misunderstood my take on the Supreme Court's inclination on the writ.
Ms. Vaccarino, I'm getting highly annoyed because these are very,
And I'll just be
very
quiet for the rest of the hearing.
Okay, ask her a question that you get, please, but that's it. Okay, so the plaintiff has intentions of relocating the child out of the state of Nevada. Is that a fair statement?
She already has.
No, she did not. The child has not gone the child. She left to go to Missouri because she had a job with Boeing. She did retire, Your Honor. And I think if you want to hear, I don't know why we're.
Because at some point in time, the child is supposed to go back with his mother. And I'm not thrilled with the idea of a child coming back to Nevada without a parent. And I haven't granted permission for the child to leave the state of Nevada. I asked that question because it's raised in the moving papers. It was. And by the way,
The motion
Missouri
is for the motion I'm prepared for today, Your Honor, and I will brief that separately if you'd like, when you get jurisdiction back, or I was going to file a motion with the Supreme Court if they ever give the case back. But we're on today for a motion to set aside the prior judgment for alleged fraud. And, Your Honor, we'd be more than happy to address any of your concerns. That child is not being kept from either parent. In the same token, my client has a constitutional right to proceed with her life, and she got a job from Boeing, and the other place she could have moved to is Florida. So that is going to be another issue pending, and if anyone opposes that, it would be in bad faith, because he already has more than alternative.
I thought you said you were going to stay quiet.
Well, Your Honor, you have my client under the gun.
All I wanted was some answers, so I had a sense about this case. Now,
and we do not.
Ms. Vaccarino, don't make me turn off your phone. Okay. All right. I've looked at the motion. I've looked at the opposition. Everybody went on and on and on and on. But to cut to the chase, because this is a serious enough issue, I am willing to reopen the hearing to allow the plaintiff, or excuse me, the defendant, to address this issue of fraud. I think it would be highly an unreasonable exercise of my discretion if I did not permit a reopening of the hearing. Now, let me address that logistically, though. Logistically, you're going to need at least a day for testimony. Secondly, logistically, this reopened hearing, who knows when it's going to happen, is going to be by video, which, creates its own set of issues because you don't have the same ability to observe demeanor, et cetera, et cetera. At the same time, I think it's a serious enough issue. Now, if I grant your motion in part, Ms. Dolson, I want you to understand what the Supreme Court is going to do. And I also want you all to understand what the future of this case is going to be. And that is that this case will be on hold at least until I have the reopened evidentiary hearing, which means the Supreme Court is going to stay your writ. They're just going to stay it and allow for the Dickerson Caragione Law Firm to try the reopened hearing. That's all that's going to happen. Now, in order to give you a day, because of everything that has happened, you're at least in November, which means that I may be hearing things, but I guarantee you the remainder of the case will be heard by someone else. Everybody understand that?
Yes, Your Honor.
Yes, Your Honor.
Ms. Vaccarino, you understand that as well?
I've understood this since last year, that this was probably going to happen.
So then it brings me to my next question. Okay? There is some allegation, and I'm trying to be helpful to everybody. There is some allegation that in order to move this case along, your client is now willing to withdraw her motion for disqualification. I raise all that. Because if in fact that is withdrawn, we can proceed very, very quickly to the next steps. And again, I appreciate that Ms. Vaccarino, you have an ethical responsibility not only to your client, but also as an officer of the court to not make this decision lightly. But if in fact your client wants to waive the conflict, waive the lack of communication on this issue, then I will open this up. And Mr. Caragione and Ms. Dolson will obviously withdraw their writ because you've waived it now. Am I correct, Ms. Dolson?
Well, we do have an issue with the waiving of the conflict because we don't believe a conflict exists, especially considering the new evidence, as well as the attorney fee judgment.
Okay, Ms. Dolson, then let me put it differently. Maybe I was inartful. If plaintiff withdraws this motion, and to the extent any conflict exists, waives it. Okay? That's it. To the extent it exists. I'll set this for a hearing to see where we're going from here. I got no problem doing that. But again, that's got to be a decision that the plaintiff and her lawyer have to make, because that will, I'm telling you, if the motion is withdrawn, obviously you're going to withdraw your request for a writ, right? Yes? Ms. Wilson?
But we have an attorney, sorry, I'll jump in here. We have an attorney's fees request too because of that, because we did go through a tremendous amount of litigation on that. We'd have to discuss it with our client is all I'm saying.
But bear in mind that the Supreme Court can send that issue down to me as well. So, and again, you may not want me to be the judge in the case. I'm okay with this, and you can just keep going and doing what you're doing. I'm simply saying because I'm on the bench for just a week over 6 months left. That's it. And with the coronavirus and all of these isolating and social distancing and everything that's been going on and the chaos, with all due respect, that the court is experiencing, things aren't happening the way I usually handle them, where everything, 30-day ordinary course, 3-month ordinary course on trials or evidentiary hearings. That's been, turned up, just like just about every department in the civil domestic area, okay? So I'm asking the question because if you want me to address what is on here, I'm happy to do so. But that has got to be a decision that the plaintiff has got to make, and then she must ask the court, the Supreme Court, to allow me to address the issue of the attorney's fees on appeal, which I can do. They can send me that jurisdiction. So that's not off the table, Mr. Caragione. So, I kind of think that's a discussion that you all have to have without me.
If I may, Your Honor, respond in the record, because my client already gave that up in the record. My client intentionally let you know that this diversion to the disqualification issue, while she believes she's not a fraud, that, there was also a clear and convincing evidence standard, and it says in or about July, not on July 2nd. That's their whole date. But it's going to cost now another $15,000 to get there, plus waiting. Now the writ stayed. So my client already made this decision and said, the money that's posted, the 24 grand, he already owes her. The child support statute changed in February. He owes her $5,000 since February because he owes her. I'm just saying. So we would file a motion to remit. But the Supreme Court wants a report from you of what you're inclined to do. Can you put our motion for child support back on calendar to address that? Because you said you didn't even know if you're giving everyone an evidentiary hearing. You have to look at the prima facie case because we think this is count up the numbers, that he has.
Okay. Let me see if I can say it in English again. If the motion is withdrawn and the Supreme Court agrees, and I know they will, to allow me to address any financial awards on appeal, okay? Just the issue of attorney's fees that both parties want. It all comes back to me. Then my intent is to have you come in, hopefully next month or the month after at the latest, and see if this case can be resolved or if I need to set an evidentiary hearing. And I will expedite that for you. That I can do. One of the things I've consistently done all these years, and y'all know it, is that I kept my Mondays, because we were given those admin days when we didn't have enough courtrooms. I kept that for the specific purpose of being able to get things in early, as far as evidentiary hearings and trials. So, I don't expect you to answer the question I'm asked today, because it's kind of a discussion you have to have. It's not
I already had.
All right, so Ms.
It's in her paperwork. That's why you said it's raised, because she asked me to do this, and we did. In fact, we tried to settle it in September of '97 and said, let's just get to the underlying issues. And listen, now they're both moved out of state. This is such a finite issue with Nevada attorneys. Okay. So yes, she's already. You can ask her yourself. She's on the phone. She's thought long and hard about it.
I'm asking you as her attorney, and it just requires a one-word answer. Is it your intent to withdraw your motion to disqualify? Yes or no?
Yes, in good faith, because she can't afford it. Yes, it's gone on way long.
I don't need to know
But
why
yes,
at this juncture. Okay, so, and I ask you, Ms. Dolson, once you get the formal notice of withdrawal of motion, is it your intent to withdraw your petition for a writ?
Like Mr. Carrickchini said, we would need to speak to our client about the attorney's fees issue, but we do dispute the attorney fee judgment, and we are requesting attorney's fees based on having to litigate this entire matter.
To me, counsel, you can have that issue sent to me. Because
We would need to speak to our
then I would have jurisdiction over everything, including attorney's fees on appeal.
We would agree, Your Honor.
Ms.
and
Dolson.
we would need to discuss it with our client.
Then you're coming back next week, God knows what time and when, because you're going to have to give me an answer. Or you can submit something in writing letting me know what to do, because I'm not going to schedule a hearing on the motion unless and until I know it's my case again.
I guess one of the questions.
Send it back to me.
One of the questions that might help it. Oh,
Go ahead, Mr.
I'm sorry. One of the questions that might help, are they also withdrawing are they agreeing to reverse the judgment on attorney's fees?
We're agreeing to allow the judge to, as I wrote in the paperwork, address how that money should be allocated, whether no one gets fees for the DQ, the disqualification round, whether one side still does, or we know that money could be hopefully waiting there to be paid the arrears that have been accruing since 2017 when she just first filed. And if we can't get that order immediately, Your Honor, we'd like an affirmative order that the DA can proceed with collecting current child support and increasing it, because they stayed it because your case was supposed to be doing it, but your case has stayed. And I can't get anyone to do it until you order it.
not understand the quandary counsel that I'm in right now.
Well,
I'm not
I don't think there's prima facie case of fraud for a trial to set aside a judgment at a high standard.
You got two choices right now, because I'm getting real mixed signals here. Choice number one is Supreme Court sends the whole thing back to me because the motion to disqualify is withdrawn and the petition for a writ is withdrawn. That's all I can do. If that's not going to, if I can't find out today that that's going to happen, because the Supreme Court's not going to send it back to me unless the petition is withdrawn, because that takes it out of their hands. And I really don't think the Supreme Court wants to have to rule on the motion if it doesn't have to rule on the motion, because these are difficult issues for everybody. You know, all the members of the Supreme Court were themselves lawyers. Many of them were trial judges. They know what these issues are, and they turn sometimes on some very narrow points. Because I'm saying this is why I need to know, because the Supreme Court will send it back down to me if the motion's withdrawn, because then it becomes a moot issue. It's moot. But until that happens, I can't go forward in this case except as to the current motion, which is in front of me, in which I've already said I'd reopen the hearing. So, let me ask you this question. Why don't you let me know what you're going to do next week?
Yes, that'd be great. Thank you, Your Honor.
I think you have to have, I counsel, you have to have a discussion with each other. Put this together so it comes back to me, because then I can address all the underlying issues. Until then, I cannot. And by the way, I still have jurisdiction over custody, unless, unbeknownst to the court, the plaintiff relocated over 6 months ago. And I don't know the question.
No. And Your Honor, our position is she's not relocated the child, and this court would continue to retain jurisdiction to finish what it started. We are not trying to deprive Clark County of current jurisdiction for the current issues that are stayed due to, because of the writ. So I'm saying
have you ever participated in a UCC JEA that I've had, counsel?
I have.
Yes, I have.
I know that you've heard me say a 3-word phrase, whether it's about me or about the judge I'm talking to. It's tag your it. Why do I say tag your it? And I know, Mr. Cargione, you've heard me say that to the other judge, or tag I'm it. Why do I say that? Because as judges, we don't keep cases that we shouldn't keep. So I ask the question, because of that, clearly the defendant does not reside in the state of Nevada. Now the plaintiff doesn't reside in the state of Nevada. And if she's been gone from the state of Nevada for at least 6 months, there is an argument that another state might have more interest in the case. But if that's not true, then it's my case, the end. No argument, no nothing. It's really them's the facts. That's it. So, what I need to have you all decide is how and when you will get the entirety of this case back to me so I can set for a hearing on some extremely old motions. So let me start with you, Ms. Golson, because you're the moving party. That if you withdraw the motion.
I'm sorry, Your Honor.
That if you get
We can't hear you.
You can't?
No.
I couldn't.
Hear me now?
Yeah.
I got my sound on as high as it can be. Can you hear me now?
Yes.
Okay. Okay, I'll be right next to the screen. You get to see my voice that much more clearly. Is it believe, Ms. Dolson, that you'll be able to get the case remanded back to me?
I believe you asked if you think that we believe we'll be able to get the case remanded back to you. Is that correct that you asked
Yes.
that?
Yes.
Again, we'd have to speak to our client about the attorney's fees issue. So once we speak to our client, we can let the court know. We can send an email CCing opposing counsel if the court would like.
Would you be willing to ask in notice of withdrawal that the issue of attorney's fees occurred in the appeal be remanded as well?
Well, answer. It's Your Honor. Me, sorry.
Mr.
Your Honor,
you're cutting. Yeah. Okay. Now speak.
Okay. The issue is not necessarily the attorney's fees on appeal. You have two issues. One, you have the attorney's fees that you granted to Ms. Jensen. So we would have to talk to our client about that and see if we can reach an agreement with Ms. Vaccarino on that. And then we have the issue of, well, Mr. Jensen now has spent a lot of an attorney's fees on not only fighting the motion and the appeal. So we would have to discuss all those issues. That's why we were saying if you could give us a week, we could let you know definitively next week because we would like an opportunity to discuss with our client.
I got no problem with that. I absolutely don't. I do think it's something that it has to be part of the motion to withdraw is obviously going to be contingent on everything coming back to me. The request to withdraw the motion is going to be contingent on everything coming back to me. That's what I'm hearing from Ms. Vaccarino. Okay? And I think it's a fair issue, but is it appropriately addressed by the trial court at that point? Yes. If there's no longer a petition for a writ, the Supreme Court no longer has any interest in addressing any collateral relief. It's just one thing they can take off their plate. So, Carol.
Yes.
Any kind of opening, let's say Thursday of next week, the 2nd of July, that you can plug them in so I can get an answer. And you can vacate that with a stipulation, and I'll just set a hearing.
Can we do the first? Ms. Dolson and I are in a settlement conference all day with Jennifer Tagliotti on the 2nd.
All right. What do we have on the 1st, Carol?
Well,
This is what COVID is getting to the courts.
And the Supreme Court wants a report by that date, Your Honor.
No, we won't get an order from the court by that date.
No, the Supreme Court.
What will happen is, if there's an agreement to do that and a timetable for getting it done, I can anticipate when I'm going to get a remand from the Supreme Court coupled with the remitter, because I have to get the remitter before I can hear this. Right now, I don't have the remitter. Or we can proceed on this motion. And so those are some very difficult questions that the parties have to be able to answer in consultation with their attorney. That's all that I'm asking. Carol, can we do the week after? Oh no, the week after is real bad. What can we do on the 1st?
okay. I think probably the best bet would be to crowd it in on the 11 o'clocks.
Yeah, because it's going to be a yes or no kind of hearing. It's not going to be where there's a lot of argument or anything. We're just going to be seeing where this is going so that, I can get some sense, and I would ask that you contact the court as well, Supreme Court, and see how fast they can send it back. Because that will tell me when I can set my hearing on the underlying motions. And I really do want to do this before the end of the summer. I really, really do. And I will carve out time for the hearing, and I will carve out time if there's any necessary evidentiary hearing so that I hear it. And I will find ways to plug you in. Although I think you can solve. So, let's.
If I, Your Honor, the Supreme Court ordered us to give them a report. Well, actually, the petitioner has to give them a report within 1 week of your hearing today. So and I believe at that time, that's why they said even to us that your decision might make their proceedings moot or stay.
Demanded within a week. I have been, as an attorney in appellate work, as well as a judge, I know well.
Judge, you're breaking up.
Are you typing again?
I guess.
He's typing again.
They will have to process.
Okay, who's
So it'll
typing?
be- So I just need to know where you're going. So I will see you on the 1st at 11 a.m. And if you come up with a stipulation, that's fine. I just need a timetable. So, and you may want to ask of the clerk of the court. It's worth a phone call. They're very nice. Ask the clerk of the court how fast it can get remanded, because that will tell me when I can plug in the underlying motions into my motion calendar, which I want to do very, very soon. We got lots of stuff to talk about here.
Justice Gibbons said he wanted to get this done right away, but they want a report as to what you're going to do. Are you opening the proceedings only as to the limited period of time addressed in these papers, the 2 weeks, the July 2nd, as opposed to, the full 2 weeks? Because that's the issue of fraud, that she wasn't telling the truth about the day. So I just want to be clear for the Supreme Court in your order what you're opening.
What I am doing today is asking you within the next 7 days, whether by video or by written stipulation, to let me know when I can set a hearing on the underlying motion. That's all I want to do. But I can't do that today because I don't know what the Supreme Court's going to do with this new set of facts. That's the reason I'm giving you a week, so that you have better information. And then when you come back, you can represent to me when I can hear the underlying motion, if that's where we're going next. So I will see you on July 1st at or about 11 a.m., okay?
Thank you.
And at that time, you'll clarify exactly what part and what you're going to hear at the reopening of these would have already been very lengthy proceedings? Because I think that's important. Because we may not reach an agreement with them. We've tried since last April.
I'm not asking you to reach an agreement on the underlying motion today, Counsel.
No, I'm asking you to set parameters in the event we don't, unless you'll do it next week, at July 1st, of what exactly you're reopening and what you're entertaining as new evidence.
Reopening the underlying motion that I thought I was going to be hearing about a year ago, until I was told, oh, whoops, there's a conflict. Okay, I know what I'm going to hear, because I already started to hear it until this issue that was close to a year ago. But I still have, in this old head of mine, a long-term memory. So you don't need me to clarify for you. Just go back to that hearing where this issue was first raised, and you know what I'm hearing. Simple.
No, I just meant if you reopen the DQ proceedings. I'm sorry, Your Honor, I just want to be clear. The record's extremely important in this case.
What that is muddy. I'm listening to mud. I will see you on July 1st at 11. Done.
Okay, do you want an order, Judge?
Yes, I would like an order, Your Honor. I would like an order from today, please.
There is no order from today because there is nothing to order.
Okay, thank
So
you.
you're deferring on
bye.
fully ruling upon the motion that we didn't get to argue today?
Counsel,
She
Judge
left.
left the hearing. So
Thank
we're
you,
going
Your Honor.
off.
Okay, I can't wait for the minutes. Thank you.
Uh-huh.
Have a beautiful day.
Thank you.